The 1978 Presidential Records Act and its amendments safeguards U.S. history. Imagine a time before 1978 when presidents could claim ownership of their official records. They had the power to decide what stayed and what went. This changed dramatically in 1974 when President Nixon attempted to destroy vital Watergate-related documents. The Watergate scandal sparked a national demand for transparency, prompting a heated debate about whether presidential records belonged to the individuals or the public. This outcry led to the creation of the Presidential Records Act in 1978, a pivotal law ensuring that these records are public property. The act covers a wide range of materials, from documents and emails to memos and social media posts, created during a president's time in office. Once a term ends, these records are transferred to the National Archives and Records Administration, preserving them for future generations. However, not all records are released immediately. The PRA allows former presidents to restrict access to some records for up to 12 years, providing a confidentiality period to protect sensitive information. Afterward, most records become publicly accessible. To keep up with evolving technology and political changes, the PRA has undergone several updates. President Reagan's Executive Order 12667 clarified the use of executive privilege to restrict access to certain records. Reagan's order allowed former presidents to request extended confidentiality for specific cases beyond the 12-year period. In 2001, President George W. Bush broadened these powers with Executive Order 13233, enabling both sitting and former presidents to claim privilege over more documents. Bush's order was controversial, as it extended the power of presidents and their families to limit public access. In 2009, President Obama reversed this with Executive Order 13489, which reinstated many of the original access provisions of the PRA. Obama's order emphasized that only the sitting president could assert executive privilege over documents. In 2014, the PRA was updated again with the Presidential and Federal Records Act amendments, reflecting the digital age's demands. The 2014 amendments addressed the surge in electronic communications, mandating that electronic records be preserved like physical documents. It also reinforced that presidents cannot destroy records without NARA's approval. With these updates, the PRA ensures that all communication forms, whether physical or digital, are treated as public property. This law plays a crucial role in maintaining transparency and accountability, allowing future generations to learn from presidential decisions. The Presidential Records Act and its amendments guarantee that each administration's legacy is documented for the public good, safeguarding our nation's history. Donald Trump faced scrutiny for allegedly mishandling documents after leaving office. He took classified and sensitive records with him to Mar-a-Lago, raising questions about potential violations of the act. Trump argued that he had the authority to declassify any documents, but critics argue that even declassified materials should have remained in government custody. The issue led to an unprecedented FBI raid on Trump's estate, sparking legal battles over the act's interpretation. This controversy brings the Presidential Records Act into the spotlight, highlighting its critical role in preserving our nation's records and holding leaders accountable. Currently under litigation, the outcome will shape how future presidents handle records and what happens when they don't follow the rules. If you enjoyed this video, like and subscribe. Thanks for watching.